Good day, Crime Talk aficionados. My name is Scott Reich, and this is Crime Talk. Well, we've got a lot of news to cover, so let's give you a quick preview. First, Judge Boyce says no cameras for the Lori Vallow Chad Daybell hearing starting immediately. Is the DA ready to file charges against Alec Baldwin? The poster child of bail reform in New York gets arrested again. A cannibal pleads guilty. And then finally, our dumb criminal of the day. Let's talk about it. Good day, aficionados. Thanks for joining us here on Crime Talk. I appreciate everyone for being here. Now, last week, several people noted that, man, Scott, you just seem really tired. Well, the reality of it is I was running around like a chicken with my head cut off last week. But don't worry. I worked all weekend, so I got caught up, and I didn't have court today, which is, well, a nice change, of course. Anyway, so I am rested and ready to go. So, you know the drill. Subscribe if you haven't, like if you do, leave me a comment below, and hit that like button. Now, also, remember, you can listen to us anytime on any of your favorite podcasting apps. So, let's go ahead and get to the docket. Let's open the record for September 26th, 2022. All right, if you haven't heard already, District Judge Stephen Boyce has issued an order banning, effective immediately, video and still cameras from all upcoming hearings in regards to the case of Chad Daybell and Lori Vallow. Now, the order came in response to a motion filed by Jim Archibald and John Thomas, Lori Vallow's defense attorneys, asking that cameras be removed from future proceedings. Why? They said that they were upset that the cameras operated by Court TV during an August 16th hearing were focused mainly on their client, and microphones had been placed on the defendant and prosecution's table. And then probably the most disturbing thing of all regarding this issue is that the prosecutors, Rob Wood and Lindsay Blake, filed a motion supporting the camera ban that was opposed by some 33 other local, state, and national media outlets. Judges in Idaho have the right, pursuant to the rules, to limit cameras in their courtroom, and Boyce heard arguments from all sides, he said, last week before issuing an order. Isn't it funny how quickly that motion was heard and ruled upon, whereas other things just seem to get put out there? Well, let's talk about this. Now, while the right to public access must be protected, the scope of the coverage cannot supersede the rights of all parties to the fair administration of justice in this case. Now, the court has previously been made aware and continues to be informed that documentaries, dramatizations, and fictionalized media focus on the defendants and the allegations in this case have already been procured and continue to be disseminated to the public. Boyce further wrote, he found no misconduct or interruptions from the media during previous hearings, and said journalists in the courtroom have been professional and respectful. But the judge is worried about pretrial publicity and noted visual coverage of the case could impede the ability to pick a fair trial. Could. We're going to talk about all this in a second. Now, the court has also previously permitted cameras in the courtroom during this case, allowing both photography and video transmission. But when the case is a sensational one, tensions develop between the right of the accused to trial by an impartial jury and the right guaranteed others by the First Amendment, including the media. The media argued citizens of Fremont and Madison counties who are paying for the case have a right to view the proceedings, especially when the 10-week trial begins in Ada County next January. Judge Boyce noted the issue and said he intends to provide enhanced access with designated seating in the courtroom in Madison and Fremont County for their residents. Basically, he's going to pipe in some sort of audio recording, I guess, so that the residents can watch it, because there won't be any cameras. We'll talk about this. Now, while Judge Boyce certainly is authorized to make the decision pursuant to rules, which he draws from, which would allow the court to proceed with visual access to the public until he determines such coverage is indeed interfering in any way with the proper administration of justice. He's only presuming down the road that it might. Now, curious for Judge Boyce to quote from the Nebraska v. Stewart case, the one about the balancing between First Amendments and due process rights. Well, in that case, the Supreme Court ruled unanimously in favor of press rights over the decision of a trial judge, finding that pretrial publicity, even pervasive adverse publicity, does not inevitably lead to an unfair trial. Wow, I can't wait to talk about this. Now, Larry and Kay Woodcock, the grandparents of J.J. Vallow, put out a statement saying that they are disappointed and distraught following Judge Boyce's ruling. Quote, although we want justice for JJ, Tylee, Charles, and Tammy, we feel he overreacted. The simple solution is not to televise preliminary hearings in order to not taint a jury pool, yet still allow cameras during the trial, the Woodcock said in this statement. Some of our immediate family, close friends, and supporters from around the globe will not be able to share in this most horrific story. This story speaks from beyond the graves. We want the world to hear the atrocities executed by Lori and Chad. Now, although Judge Boyce revoked video and photographic coverage, he wrote audio proceedings will continue to be permitted using in-courtroom microphones. It's unclear if a live audio feed for public dissemination will be allowed. Now, the judge's audio and video coverage decision cannot be appealed according to the Idaho Court Administrative Rules, which is rather disappointing. Let's say, just to say, it's rather disappointing. Now, let's also be realistic. If it had gone up, it would have been on an abuse of discretion standard, and therefore, it's pretty unlikely that he would be overturned. Although, let's talk about some specifics from the order, okay? Now, the first thing that this decision reminds me learning way back in law school where Professor Brody would say, bad facts equal bad law. Sometimes cases with bad facts go up and they create bad law. It just doesn't make any sense. When I say that it goes up on appeal. Well, he also had a little saying, weak decisions come from weak judges. And I think this is one of the most wishy-washy opinions that I've read in a while. Don't get me wrong, I read a lot of wishy-washy opinions from judges. But this one, he says he's taking on the motion because the defense doesn't want cameras in the courtroom. Oh, it's going to make my client look bad. Okay, I get it. The defense is doing their job, protecting their client. But what is disturbing here is the prosecution joined in the motion, okay? So we have a couple of things building up here, ladies and gentlemen. Now, I would estimate in any homicide trial that I've done, including multiple homicides, the trials have never gone on longer than 3 weeks. And frankly, I think they were just as complicated as this particular case. So when they say they need 10 to 12 weeks to try this case, I mean, we are getting into O.J. Simpson, Judge Ito kind of situations here, okay? This case should not take that long. So we have the judge here in this case who said, basically, after all, I've got both the prosecution and the defense agreeing on a death penalty case, so I must take this into consideration. They're so concerned. There's a couple of things that I took issue with in here. Now, Rule 45 specifically says the presiding judge maintains the right to limit audio-visual coverage of any public hearing when the interest of the administration of justice requires. Authorization may be revoked at any time without prior notice when in the discretion of the court it appears that audio-visual coverage is interfering in any way with the proper administration of justice. But yet the court cannot come up with a single fact in which he says that the audio-visual coverage is interfering with the court. He says no one from the media did anything wrong, but then he says, well, I do kind of agree. Court TV did focus quite a bit on the image of Lori Vallow, looking at her gestures, even when she wasn't speaking. Okay, probably should have focused more on the people that were in fact talking, i.e. the attorneys, or if there were witnesses involved, to do that. So, but either way, guess what? We've talked about this. This is what a jury is going to be looking at. When that evidence comes out and it's bad, they're looking over there at the defense table, seeing how the defendant reacts, okay? Then the judge says, well, there's been documentaries out there. There's been a Netflix one. I watched it the other night. I thought it was pretty good. But guess what? It's all based upon information that's been released from the prosecution. Nowhere does the court say that this is false information, which is a little concerning that the prosecution went along with this. Okay, I've said this before. I think courtrooms should be in every courtroom, from state court to federal court. Heck, the United States Supreme Court at least has audio recordings in there, and maybe one day we'll actually have video of it, to come into 2022, for God's sakes. There's nothing secret that's going on here in these courtrooms, ladies and gentlemen. It shouldn't be a secret. When we start having secrets in courtrooms and people aren't allowed to see what's going on, you can't access court files, it's all being done to protect the interest. What could be more prejudicial than the reading of the charges in this particular case? Lori Vallow is accused of being involved in the homicides of her children, JJ and Tylee, and conspiring with her now husband, Chad Daybell, regarding the death of Tammy Daybell. That's pretty prejudicial, okay? All the other stuff, guess what? Doesn't matter. And I've said this before, and the court's order and the courts that we've talked about have said this. Just because the case is pervasive, that there is a lot of news out there about the case, doesn't mean that somehow you're going to get a fair trial by banning cameras in the courtroom. Frankly, I think it's going to create a situation where there's going to be more speculation out there, and the information that gets out there isn't going to be accurate because people can't say, nope, that's what they said in court. That's what was in the motion. That's what was represented by the defense or the prosecutions in their motions. There's going to be more people, frankly, that can put on their little tin hats and start speculating when they want to keep the truth from the people. And in the court's ruling, they didn't say one thing that was going to affect the jury trial. Said, this that took place by these hearings taking place is going to affect these two individuals from receiving a fair trial. Not a scintilla of evidence. He's just concerned that it could, right? Judge Boyce is concerned it could affect the right to a fair trial. It hasn't. There's been no indication, no evidence was. Simply put, the defense doesn't want it, and hey, the prosecution agreed. And guess what, Judge Boyce? The legal standard, and you know this, there's been high publicity cases all the time. And miraculously, they're able to seat a jury. They're able to find 12 people and the sufficient number of alternates. And in every case, think about it, even in the Rittenhouse case, most of those jurors said, I heard about the case. You betcha. Who wouldn't have heard about it? Think about the Derek Chauvin matter. They televised that one as well. People said, yeah, I knew about it, but guess what? I'm willing to put out of my mind what I've heard. I haven't formed an opinion, and I'm going to listen to the evidence that comes in legally and properly from witnesses on the stand and consider legal evidence that is admitted through the appropriate foundation being laid. That is the legal standard. Just because someone has heard of a case doesn't make them ineligible to sit on a case. And I don't think the judge necessarily took that into consideration. And if they're hearing evidence, wouldn't you want it to be the most accurate of all? Right? By what you would think would be the evidence being subject to cross-examination? Of course you would. Now, all the speculations, all the weird theories about who's controlling this and taking over, it's only going to exacerbate this, and frankly, it's going to chill the truth from coming out. What really is disappointing here is that the prosecution went along with this motion. They should have said, you know what, we have a heavy burden of proof beyond a reasonable doubt to each and every element of the charges, a burden that we gladly accept. And we are so confident not only in our case, but our officers, the agents that worked on this case, and our abilities as prosecutors. We want the world to see how justice is carried out here in the state of Idaho. So it makes me think maybe they're not so confident, and if things go south, at least it's not televised for the world to see, I guess. I don't know. Disappointment. I hope the judge would reconsider his ruling, but I don't think he will. We have a judge who, frankly, this is his first really big case. He was a magistrate judge prior to this. Looked like he was handling divorce matters and things of that nature before he became a district court judge. And next thing you know, you got a case that has the entire world watching, and he doesn't want the world to see if he makes it right. Well, he may be going on the wall of shame of judges, right up there with Judge Lancey Ito from the O.J. Simpson days, who turned a 3-week trial into an 8-month, 9-month cluster. Exactly. All right. So before we get to our next story, I thought it'd be interesting to follow up on one of the cases that we had been following. That's right. That's the status of the case of Suzanne Morphew. As you may recall, Suzanne Morphew's husband, Barry Morphew, was charged with her death, but the prosecution didn't have a body in this particular case. And frankly, it was amateur hour at the district attorney's office as well as the Colorado Bureau of Investigation when they were investigating that case. Hell, even the lead investigator was basically fired for saying that the case wasn't ready to go to trial. But the district attorney, Miss Stanley, went forward, thought she could make a case, and she was clearly outmaneuvered and outlawyered by Iris Itan, the lead attorney for Barry Morphew. Ultimately, in somewhat embarrassing circumstances, because her license was suspended because she hadn't fulfilled her CLE requirements, she had to dismiss the case. But remember what she said when she did that back in, April, I think it was, that they were certain that they were going to locate the remains of Suzanne Morphew. In fact, they were positive they had a good fix on a location, but they were just waiting for that snow to melt. Well, we've had May, June, July, August, and September, and it's been hot, and it's nearly October. I wonder how that search for Suzanne Morphew is going on. That's right. Nothing from the DA's office. Do you start to see why, as a criminal defense attorney, I'm skeptical of not just everybody, but especially when the government says something? Because usually when they say they're going to do it, well, I don't know. If they do it, they get it wrong. But let's move forward. Another case. How about that Alec Baldwin case? Remember the big report was supposed to come out? Well, it actually looks like there may be some real movement. Because I was thinking, this Santa Fe district attorney, Mary Carmack Altwiles, should, either file charges or tell everybody, particularly Mr. Baldwin, that they weren't going to file charges. It's stressful enough when somebody's actually charged, but the unknowing can be just as stressful. Well, guess what? She has filed an emergency request from the people that pay the bill, basically like the Board of County Commissioners. They call it the New Mexico Board of Finance, where she needs another $600,000. And that's so that her office would have funds necessary to prosecute up to 4 people in connection with an incident that took place near Santa Fe. Now, she didn't disclose in that report or that financial request who those 4 people are, but noted in the request one of the possible defendants is a well-known movie actor, Alec Baldwin, and the prosecution could require up to 4 separate jury trials. And during the finance board meeting, Ms. Carmack Outwiles said her office has been awaiting FBI reports, phone reports, and interviews for the last year, but the sheriff's office final report is expected within a week. Now, when the report is received, her office would be ready to move forward with criminal charges against those involved if she decides to do that, according to what took place at the meeting. When asked what specific charges could be brought, Carmack Outwild said her office attorneys are certainly looking at all the homicide statutes and any gun statutes under the New Mexico Criminal Code. Now, during the Tuesday meeting, she explained her office needs the funds because we need an almost full-time attorney and someone who is very experienced on complex cases and very experienced with litigation, she said. Additionally, that person will then need a paralegal support staff, potentially an investigator, would be for investigators to follow up on missing pieces. The prosecutor noted that the funds would also be used to pay for expert witnesses and a public information officer to field media requests on the case. She said that her current PIO right now is also a working attorney in their office, And frankly, they need somebody that can handle those requests, to answer emails or even read them. And so that is why they have asked for the budget. The prosecutor noted that funds would also be used to pay for the expert witnesses as well. The State Finance Board ultimately awarded the office $317,000, about half of what they sought. The office will request a special appropriation for the remainder of the money. As I've mentioned this before, as a young prosecutor, when asked why are we taking this case, is it really worth, the money? And my boss said, there's always money for justice. They'll find the money. So hopefully that case will be moving forward. I mean, my gosh, how long has it been now? Over a year? What are we doing, people? What are we doing? It doesn't take that long. The job expands to the amount of time given. Next, a New York City career criminal, once promoted as a poster child for bail reform, is now wanted by police for attempted murder in a broad daylight shooting in front of St. Patrick's Cathedral in Midtown Manhattan. Pedro Hernandez is suspected of shooting into a Mercedes on 5th Avenue and 50th Street at about 5:45 p.m. on August 28th. Hernandez is believed to have lost cash and gold jewelry to a pair of hustlers in a game of three-card Monte, and then lost his temper when the men refused to return his lost valuables. As the men drove off in their red Mercedes, Hernandez allegedly fired a single shot into the driver's side door. Police say then they climbed into their own car, a black BMW, and pursued the Mercedes to the parking garage on the Palace Hotel on Madison Avenue. The men dumped Hernandez's belongings inside the garage, which was scooped up before fleeing. Now, in 2017, at the age of 17, Mr. Hernandez became the face of the city's bail reform when he was sent to Rikers after refusing a plea deal for a 2015 shooting of a 15-year-old boy at a Bronx bodega. The deal would have let him walk without jail time, but he maintained his innocence and was put behind bars with a $250,000 bail for a year awaiting his trial. His case garnered national attention, and he was eventually bailed out by the Robert F. Kennedy Human Rights Foundation after the amount was reduced to $100,000. The charges in that case were dropped before trial when a witness refused to cooperate. Please go to CrimeTalkSearch.com, sign up for a background subscription service. You'll be happy you did. If there's anyone out there you were ever curious about what was in their background, now is the time to do it. If you're going to get involved with somebody, now is the time to do it. When you go to CrimeTalkSearch.com, you put in the name, literally millions of public records are searched, and a report is generated. And it's going to give you a report. If they have multiple social media accounts, you're going to find it. If they have multiple phone numbers, multiple email addresses, it's going to be found. And more importantly, you're going to get information regarding criminal history. Hopefully the person you're searching has none whatsoever. But if it's there, it's going to be found. You're going to get everything you'd want to know, whether you're going into business or whether you're going into a personal relationship. You're going to be able to find out the information you want to know. So go to CrimeTalkSearch.com, sign up today. You'll be happy you did. Even cannibals can be found guilty. That's right. Even crazy people. A Michigan man accused of killing, mutilating, and eating parts of the body of a grinder date in 2019 pled guilty to murder and mutilation this week. Mark Latinsky initially pled insanity in the killing of 25-year-old college student Kevin Bacon and was ruled incompetent to stand trial, but he was found competent in October of 2020. Now, Bacon was reported missing on Christmas Day on 2019, a day after meeting in person with Latinsky. Bacon's body was found in Latinsky's home 3 days later. Now, Latinsky was found incompetent to stand trial in February 2020, but after 8 months of treatment, he was declared competent. Now, records show that Latinsky was committed to a hospital 4 times for mental health issues and was known for stopping his medications on his own. A hearing in the case is scheduled for October 18th to determine if Latinsky, if convicted of first-degree murder, second-degree murder, or manslaughter. His attorneys told the court that their client was pleading guilty against the defense team's recommendation. Although this is not an outcome the defense attorneys wanted, the attorneys say, I think it's Mr. Latinsky's best interest. We do have to follow his wishes. We have discussed this matter, and consistently, he's been very clear more than once, multiple times, on his choice and of his own reasoning. The attorney said in court that she believes Mr. Latinsky would be better served in a hospital than a prison. Mr. Bacon's father, Carl Bacon, was in court for the plea and said he's relieved the family won't have to relive the murder in court. Which brings me to a thought that I was thinking about. I don't know if you all have watched that Dahmer series on Netflix. I think it's like 3 movies, 3 or 4. One word to describe this: disturbing. Okay? Weird dude. Everybody knew he was weird. Nobody called him out on it ever. And just weird dude. What's even more disturbing is the number of times in which he was nearly caught, usually with some sort of dead body in the car or in the house, the apartment that he lived in, and he was never, ever arrested. Disturbing, ladies and gentlemen. Finally, our dumb criminal of the day. A man was arrested and accused of urinating on a family after his demands for money were left unanswered. It's alleged that 18-year-old Enrique Alvarez Salinas, who appeared to be intoxicated, accosted a family as they arrived at their home on Sunday evening. Alvarez Salinas allegedly demanded money from the family as he swung a beer bottle at a victim. Despite the family's attempt to calm Enrique down, he then urinated on the victim and in front of the victim's house. When friends of the victims arrived at the home, Enrique hopped into his truck and sped off. Police quickly spotted Enrique's vehicle, which blew through several stop signs, crashed into a car, continued fleeing, and ultimately crashed a second time. Enrique tried to flee on foot but was tracked down by a canine unit. Enrique resisted as he punched the canine and attempted to punch the canine partner. Both the deputy and canine were not injured. He was also charged with resisting assault and assault against a peace officer and striking a police dog. Wow. Talk about things escalating. Hey, can I borrow $1? To urinating on your lawn and that family, and then beating up a police dog, right? You know what they say? No good story ever began with, so we went out to have a salad, right? We went out drinking a couple of beers. That escalated. Enrique, bad move, buddy. I'm thinking alcohol and you do not get along. All right, I want to thank everybody for watching. Hope you have a wonderful day, and we'll see you next time on Crime Talk.